So let us say 50% of your participants are either lawyers or wanting to be lawyers or wanting to have a career in law, which is very nice and which is very exciting for the simple reason that we are actually having this course, which is a niche area where we are focusing on documents. Now, I am going to sort of give you a kind of a curtain raiser as to what is it that I will be discussing with you. And somebody is unable to hear. Anil Jain is unable to hear. Raghav, can we address that?
Anilji, you have to, sir, he'll not be listening to us right now. He'll connect to the audio.
Okay, fine. Okay.
You
So
can
no
let it.
problem at our end, right?
Yes, we're fine.
Okay, okay. So basically what I was coming to is that as a lawyer, when we look at all of this material that is there in the course, there are two things which catch my attention, which is what I wanted to share, and I also wanted to share a little bit of a roadmap as to what how I would be engaging with you, and how I would like to sort of share whatever thoughts I have, experiences I have about the art of cross examination, the philosophy of cross examination, the methodology behind cross examination, and how all of that applies particularly to an expert witness, because cross examination in general and cross examination of an expert witness are two different things. So let me put it very clearly right at the beginning. Cross examination is not a generic term. Cross examination of a doctor is essentially different. Cross examination of all other forensic experts is going to be slightly different. Cross examination of any other witnesses are going to be different. Even within witnesses, the more so it's like an ocean. The more you go into cross examination, you will find cross examination of an investigating officer is absolutely different from that of a punch witness. The cross examination of a first informant or a complainant is going to be different. Cross examination of a victim of an sexual assault is going to be different. So cross examination should not never be looked at as a kind of a generic term. When you say cross examination, the first thing that normally a lawyer would ask you is that cross examination of whom, because he will need to prepare accordingly. There can't be a generic preparation for a cross examination. Having said that, I'm going to first give you the basic skeleton of how the law looks at evidence. Let us not call it cross-examination, because cross-examination is only 1/3 of what the entire evidence is all about. So what are the remaining two parts? The remaining two parts are examination in chief, obviously cross-examination sandwiched in between, and after that there is re-examination. Now, to just simplify things, because we are dealing with a spectrum of people who are practicing and people who are studying law. So I need to address both the ends and not try to derive something which is a bare minimum. So examination in chief is where the report is introduced. Now, what report am I talking about? We are having this class of question documents where a forensic expert is talking to us about the entire way or manner in which a forensic analyst or a handwriting expert, to be precise, is looking at a disputed document. Now, that handwriting expert will tell us that these are the various issues that she will look at or he will look at. And this is the methodology, this is the procedure on the basis of which she will compare two documents and arrive at a conclusion. That conclusion is normally what we call as a forensic report. Okay. Now, this forensic report forms the basis of those three legs of evidence. First is your examination in chief, then is your cross-examination, and third is your re-examination. Now, what are these three steps? Before we come to that, let me just shift the gears a little back and take you to that report itself. So by the end of this lecture today, I believe that Madam will teach you how finally a report is prepared. So how does this report come into court? Now, again, we have to divide ourselves into two parts. One is civil and the other one is criminal. Obviously, we can't all be saying that this is just a class of criminal law, because there is a possibility that you might encounter a forensic analyst handwriting expert report even in a civil proceeding. It could be a proceeding which is a civil suit. It could be a proceeding which could be an arbitration. It could be even a consumer dispute. You can find a handwriting expert report even in civil proceedings. Now, in a civil proceedings, typically it is introduced by some kind of documentation, either under an affidavit by the plaintiff or the defendant or the applicant or the respondent who wishes to prove a document. So the simple logic behind introduction of a document is that the person who wants to prove something introduces a document to prove it. If I want to prove that I was present uh, in this online meeting at so and so time, I will introduce a document to prove it. So basically, uh, the person who wishes to prove a fact will introduce a document towards proving that particular fact. Now, keeping in line with this proposition, the expert who is there, the handwriting expert, will either tender the opinion on behalf of the plaintiff or the defendant, the applicant or the respondent, whatever nomenclature you want to use, depending on the proceedings, typically under an affidavit. And then that handwriting expert will prove the particular document. How will it be proved? Again, depending on the nature of the proceedings, it can be proved sometimes under an affidavit. Sometimes we have to go into the witness box and prove it. When is the difference? That we will talk later. But in short, in a civil proceeding, this document comes on record by way of proving, or this document is proved. Then what happens? So this is your examination in chief, typically. Now, an examination in chief may happen in civil proceedings. Examination in chief is basically the person who is trying to prove a fact. Let us say it is the plaintiff who is trying to prove a particular fact. That person will then summon that particular witness. Let us say that witness is the forensic expert. And what will that forensic expert prove? That forensic expert will prove his or her own report. And the manner in which all of that is done is examination in chief. You are proving your own case, which is why it is called as examination in chief. Now just shift to criminal law. In criminal law, who is the complainant? Normally, we have the state, which is the complainant. And what does the state file? The state, through the police station, will file a charge sheet or a final report. Now, where will this opinion would be? Logically, it would be part of the investigation, because that document or the case is, let us say, about forgery, and the opinion would pertain or be relevant to whether the document is forged or not. So where will it be found? It will be found in the charge sheet. So now, drawing an analogy from what I said just 2 minutes ago, in the civil proceeding, it is introduced by the witness for the first time. A copy is given to the other side in advance so that the other side knows what are the content of the document, and then cross-examination can happen on it. In criminal proceedings, the charge sheet is given at the very beginning of the trial. So along with that entire compendious charge sheet that you have, you may have the report. Why I'm saying you may have is sometimes the report is not available in the charge sheet. It is filed subsequently. But nevertheless, the accused or his lawyer gets an opportunity of seeing that report much in advance before that report is proved by the handwriting expert. Now, what do I mean by proved by the handwriting expert? What is this whole thing of proof? So the handwriting expert goes into the witness box in a criminal trial, says that, yes, this is the report prepared by me, says that this report was prepared by me under instructions of the investigating officer or a representative of the investigating officer. Normally, that is proved by what we call as a forwarding letter, which that expert receives from the police station or the investigating officer's office. According to the instructions in that forwarding letter, she does what is expected for her to do. So she would be sent a disputed set of documents, which need to be examined and found out whether these are bogus, forged or not. and she will be sent an admitted set of documents. She will compare the two and finally come out with a report. Report is part of the charge sheet. So far, so good. Now the witness comes into the witness box. Witness box, she proves that entire document. How does that entire proof happen? We will see on the next occasion. But take it for the present discussion that it gets proved, it gets marked in the court, and then we begin what is the most interesting part of evidence, which is a cross-examination. Now, there are some rules of examination in chief. What are those rules? Again, we'll see on the next occasion. There are some very different rules of cross-examination, but essentially what is cross-examination all about? Cross-examination is an attempt to dissect that particular document and to disprove its credibility. Whether it is a civil proceeding or it's a criminal proceeding, the aim and effort of the other side, the contesting side, it could be the respondent, it could be the accused, it could be anybody who is contesting that particular report. That person's entire endeavor, that person's entire effort is to do what? Is to destroy the credibility of the report, not to destroy the credibility of the handwriting expert. And this is something which is very interesting because lawyers, sometimes tend to do the other. Instead of destroying the credibility of the report or attacking the credibility of the report with the technical ammunition that they should be doing, they try to attack the credibility of the person making the report. And what are the pitfalls of doing that, we'll discuss on the next occasion. But that is something which we will discuss, and we'll find out what is the better course, whether to attack the person or to attack the report. Now, when I say attack the report, what do you mean? The report will consist of various conclusions, but those conclusions are not in thin air. Those conclusions are based on some methodology, some procedure which that person has adopted. Now, in a handwriting expert, it could be the comparison. Comparison could be of various types. I don't want to go into the technical details. That is ably taken care of by Titiksha madam. So she'll tell you what those technical details are. The question that would come into your minds is, for understanding how to cross-examine, supposing you are a lawyer who's attending this course, the question that will come to your mind is, why do I have to learn all these technical things? Why can't I simply have a surefire method where a lawyer comes and tells me, look here, I have conducted 200 cross-examinations of handwriting experts, and these are your, expected question sheets. This is exactly not how it is supposed to be done. So if you look at any cross-examination, as I said, it is not a generic term. It's going to be unique. It's going to be different. So therefore, what is it that one studies, or what is it that one learns by way of experience? What one learns is the jurisprudence or the methodology of how you look at a cross-examination. So I just gave you one clue or one hint. The hint is, don't attack the person, attack the report. Don't question the credibility of the person, question the credibility of the report. Second could be to find out by way of your technical knowledge as to whether there is any mistake in that report. Mistake could be either a direct mistake or an indirect mistake. Direct mistake means something which ought to have been done was not done. Indirect mistake is something which ought not to have been done has been done. So you call it act of omission or commission in legal language. So you have to examine that report for both, whether there's an act of omission or there's an act of commission. And tell me, how would you able to, or how is it possible for you to find out whether there is any omission or commission unless you know what the whole procedure is, which is the entire endeavor of this class. So when I, for example, to give you a very, very practical example, when I was cross-examining a voice analyst, I literally had to go through volumes of voice analysis. And what is voice analysis, spectrography, how it is done, etc., etc. So you can't really escape the technicalities of it, which is why this entire course was born, so that there could be a marriage between lawyers on one hand who want to cross-examine or who want to conduct the evidence of handwriting experts or any experts for that matter. And on the other hand, forensic persons who know their science or their technical art very well, and they can explain it in a very simplified manner to people like us, so that we are well armed with it. So coming back to the conversation, the second point is that yes, you must be very good on your technicalities. If you want to, to put it in very simple and crude terms, perhaps, if you want to beat a doctor, you have to be half a doctor. If you want to beat a forensic scientist, you have to be half a forensic scientist. So if you want to be even a quarter of forensic scientist, then you must attend all these lectures and understand what the entire art of forensic science, especially when it relates to question documents, is all about. That is the second part. Third part is try to examine the report on the principles of precedents. Now, what do you mean by principles of precedents? You need to go and do your legal research. Has handwriting expert been summoned to court? Answer is yes, thousands of times. So you would have dozens of reported judgments. Now, I'm just going to share some sections with you which I want you to read up for the next lecture so that we can talk more on the law part of it. The first section is going to be section 45 of the Indian Evidence Act. What does it talk about? It talks about opinions of experts and how they are relevant. Okay, that is 45. Then you have section 293 of the CrPC. Why we are discussing 293 of CrPC is when it comes to criminal law, there is a slight departure, there is a slight modification which has come in by way of amendments recently. Essentially, what it says is that if there is a report of a government accepted forensic scientist, then there's a list of those scientists, so there is no ambiguity. Nobody can stand up and say I am a government recognized scientist unless his name is included in that particular list, which is there in section 293 itself in the statute. So in that scenario, the report that he or she submits can be directly entered into evidence. It becomes admissible. Now, how does it become admissible? What is the exception? All that we'll study on the next occasion. So that is the third point. You have to examine it whether you have to examine it on the touchstone of whether there are any legal precedents which teach you what has happened in the past, how this cross-examination has happened, whether there are any precedents, whether there are any legal case laws revolving around all of that. And lastly, you have to look at something which I would call as legal logic, or logic. What does logic tell us? That every methodology has to be logical in some manner or the other. So we will be talking about something which is called as a chain of custody. Now, the chain of custody is very important so far as a report is concerned, a forensic report is, because the scientist has to first see whether the material that is coming to her, in this case, it would be a document, whether that document is free from any tampering, whether that document is brought in a sealed envelope, whether that entire custody is maintained so as to ensure that there is no allegation of any change, manipulation, interpolation, and all of that. So that is the last part. So these are the four, let us say, the limbs of how a forensic analyst or a forensic scientist can be cross-examined. And last is that third limb that I was talking about. So first you have examination, then you have cross-examination, and last is re-examination. What is re-examination? Re-examination, as the name suggests, is not to again examine that accused or the witness. Re-examination is basically something where you can plug the loopholes, bona fide loopholes, which are left in the examination in chief. So if the examination in chief, let us say, refers to a particular incident, that incident is also talked about in the cross-examination. But in the examination in chief, only some part of that incident is revealed. You can, in the re-examination, now re-examination is not for defense lawyers. The re-examination is largely for the prosecutors or the plaintiffs who want to prove the document. So if there is some ambiguity in the examination in chief, which is again sought to be talked about in the cross-examination, that can be addressed and taken care of in the re-examination. So this is, just to sum it up, these are the three parts of how the evidence would look like. Just like a final word, I will say before I stop, is that by the end of this lecture or perhaps the next lecture, you would have a report. And what I would suggest is, and I have put it across to Raghav also, who's also on the same page with me, what we can do as a very interesting experiment is, we can have a report circulated, of course, with all the names, etc., all of that taken out so that the confidentiality is maintained. But a real report, a report like any other report which would be prepared by a forensic handwriting expert. And then what I will do is I will prepare some questions. Now, I'm not going to have a kind of a drama where I'll be asking those questions to the handwriting expert. That is not what the idea is. The idea is to share those questions with you so that you understand where those questions come from. See, because once you understand the art of asking the right questions, then answers are a matter of course. Answers really don't matter. It is like when you have a good, strong bow and an arrow and you hit it at the right place, then whether it really misses that target by a few inches here and there doesn't really make a difference because you're making the right efforts. So my endeavor, my idea would be to discuss all those questions with you and then tell you why those questions were, basically why they came into my mind. So this is going to be our framework, maybe from the next lecture or the lecture after that. And I'm looking forward to interacting more with you. I think I have come to an end of what I had to say. I had a hard stop at 7:30. I'm sure you would be bursting with questions, but just hold on to your horses. Next time we can address all of them. Thank you so much, Raghav. Is there anything that you need to know immediately? Then I can, maybe spare another minute or so.
Sir, as far as I am concerned, I think we are good here. And this was just perfect, very perfect. I was only wondering, when did you get the time to prepare this? Like
There is no preparation. I'm just
yeah.
speaking my mind.
Then I realized that you were preparing for the last 30 years. So I should not be thinking ki time kab mila. Because this occasion, you all should know that, sir, we only contacted sir a couple of hours ago and thought that we'll do this webinar today. And then we made the notification and you guys also joined. So thank you so much, sir. And we let Tiksha ma'am take over now. And guys, all the questions that you have, you can send in the chat box. We'll keep them. And sir is going to reappear on Monday. And everything that he has talked about, I know the way he did it in waves. Ki abhi ye karna, ye karna, ye karna, and then he tells that, this is what we'll do in the next session. So wo curiosity ka keeda, I know where it is. So Monday is going to be a deep dive into whatever he has talked about, and it's going to be amazing. We have done this in other courses as well. POXO, NDPS, all those who have joined us, they know that these sessions are marvelous. So right now we focus on what sir has already delivered, what is coming next, which is also equally important, what to know about the reports. And then the next session is going to be superb. So give me your questions. We'll keep them. And in the next session, once we are done with what sir has to deliver, we'll take all those questions and everything will be addressed.
Yeah, just one parting word. Just focus on all the technical aspects because believe you me, those technical aspects are really going to be your savior when the time for cross-examination comes. Thank you so much.